Welcome to the University of Mississippi School of Law, the fourth oldest public law school in America. We are absolutely delighted to be able to host the Wylene Dunbar and Jack Dunbar Lecture in Law and Philosophy. Here in our personal note, it's been a pleasure to be able to get reconnected with my friend and former law school classmate, Wylene Dunbar. Wylene, thank you so much for your attention. A little bit of a shout out to Marty and John Dunbar for their very gracious participation in the programming here for this lecture series. And special thanks goes out to our Associate Dean for Administration, Sandra Cox-McCarty, who handled all of the event planning for this, as well as Associate Dean for Research, Will Berry, who was on the planning team. And finally, I would like to thank the philosophy department chaired by Dr. Stephen Soltetti for allowing us to collaborate on this very important lecture series, as well as many other projects that we collaborate on. One of the most important collaborations that we have is with Dr. Aaron Graham. Dr. Graham is a member of the faculty in the philosophy department, but we get to steal him away a little bit. He's an affiliate faculty member here at the law school where he teaches recruits. Aaron has been tireless in organizing this event and is primarily responsible for its success. Aaron.
Welcome. Good afternoon. Welcome to the 2026 Jack Dunbar and Wylene Dunbar Lecture in Philosophy and Law. As Dean Slayback said, I'm Aaron Graham, Assistant Professor of Philosophy in the Department of Philosophy and Religion. Before I introduce our speaker, I would like to thank several people for their role in making today possible. As Dean Slayback said, the Dunbar Lecture is a cooperative effort between the Department of Philosophy and Religion and the School of Law. So I'd like to thank my colleagues on both the philosophy and religion side and the law side for supporting this event, but most especially my department chair, Stephen Soltetti, and my department administrator, Brett King, for all their logistical help putting this on. And then on the law side, Dean Slayback, Associate Dean Sandra Cox-McCarty, and Professor Will Berry for organizing things on this side, and of course for hosting us today. Thank you very much. A special thanks also to Professor Catherine Moses for designing our terrific flyer, and to John McCushton and Marissa Atkinson in marketing and communication for publicizing the event. At the conclusion of today's event, we will adjourn to the atrium right out here for a reception sponsored by the Philosophy Forum Series and the Center for Practical Ethics. So thanks to them as well. And finally, thank you to the University Lecture Series Committee for additional financial support. We have a number of eminent guests with us today. I see vice chancellors, deans, department chairs, directors of centers and institutes, prominent members of the local bar, even past and present holders of public office. And I thank you all for being here. But I most want to recognize the members of the Dunbar family who are here with us today. John and Marty Dunbar, son and daughter-in-law of the late Jack Dunbar, and of course, Wylene, co-founder, along with Jack, of the Dunbar Lecture in Philosophy and Law and visionary in chief of today's events. If not for your generosity and your commitment to Ole Miss, none of this would be possible. Now, Dunbar Lecture has been delivered by a number of preeminent philosophers and legal theorists over the years: Ronald Dworkin, Martha Feynman, Stanley Fish, Joel Feinberg. I would be remiss if I didn't mention my own teacher, Brian Leiter, and that's just to name a few. Today, we add to that distinguished group Dr. Scott Shapiro, Southmayd Professor of Law and Professor of Philosophy at Yale University. In addition to being a leading scholar in the areas of jurisprudence, and international. Professor Shapiro is also expert in cybersecurity and artificial intelligence, a founder and director of both Yale CyberSecurity and Legal AI Labs. Today, Professor Shapiro will be speaking to us about the automation of legal reasoning and what that has to do with early modern German philosopher, polymath, and lawyer, Gottfried Leibniz. Professor Shapiro will be speaking for about 45 to 50 minutes. Then we'll open the floor for Q&A. We will conclude by 5:30, at which time you are all invited to join us in the atrium for the reception. Without further ado, please join me in welcoming our 2026 Dunbar Lecturer in Philosophy and Law, Dr. Scott Shapiro.
Thanks, everyone. You know this isn't bankruptcy class, right? I just want to make sure you're in the right room. I don't think I've ever seen this many people before. It's the first time I'm speaking in public. I've done this before. Okay. So first of all, I want to thank Aaron, who really was tireless, put all this together. The dean and the officials of the University of Mississippi Law School and Greater University. I mean, everyone's been so incredibly nice. I also really particularly want to thank Wylene Dunbar, who endowed this up until now quite amazing lectureship. Wylene is a lawyer and also a former philosophy professor, but I did not realize until I spoke to her a couple of days ago that also she was into computers. And so that's really the trifecta, computer science, law, philosophy. So I'm really, really honored and grateful that you showed up, and hopefully we can talk about some stuff that's interesting. So first thing I want to say is that when you teach philosophy and you do philosophy, it's a very solitary activity. You just sit and think and write. Now that I do a lot of sciencey stuff, I work in groups, and I just want to acknowledge that a lot of the work that I've done here has been done with my colleague, Professor Richard at Yale University, who works on automated reasoning and program verification. You'll see why we work together hopefully through the lecture. Okay. List the 10 great philosophers of Western philosophy. You probably would mention Leibniz. Of course, he was a philosopher, but also he was a historian. As Aaron mentioned, he was a lawyer. He spent a lot. He went to law school, and he actually was given a job, but decided not to take it as a law professor. He's often considered the father of AI, coming up with the idea of symbolic reasoning engines. He actually built a machine to add numbers, one of the very first mechanical adders. He pioneered the use of logic in law, and I'll talk about why that's important in a couple of minutes. And he dreamed of one day automating legal reasoning. And this, of course, makes sense if you're a lawyer. Of course, you'd want to automate it away. He famously said to take a pen in hand, sit down at the abacus, and having called in friend, if they want, say to each other, let us calculate. So what Leibniz envisioned was that one day we would be able to automate legal reasoning in some kind of decision machine. And then if you had a disagreement, you could invite the person you're disagreeing with into the room, crank up the machine, and get it answered. So what I want to talk about today is, can we do this? If we can, how? If we can't, why? And the answer will be yes, no, maybe. And you'll say, okay. Why do we want to automate legal reasoning? Well, as people probably know, there's a real crisis of legal services in the United States. People say to me, oh, you teach lawyers about AI, and you're trying to put your students out of business. And I say, you know, you're under the impression that 99.9% of Americans have access to lawyers, and they don't. And so instead of talking about how we should be afraid of AI, I want to talk about what are the promises of AI in order to bridge this access to justice gap that just people in the United States just don't have access to these services. This is also very important for businesses, as we all know, everything AI, especially when it comes to regulation. In the United States, we have a lot of high-tech businesses, and a lot of those businesses are subject to regulation. And so general counsels generally spend 2 to 3 times the amount for compliance in the United States than they do for the compared to their global counterparts. So if there was a way to automate and to make this easier, that would be good not only for low-income households, but also for businesses as well. Okay, so what's the lesson? One of the things that I'll be drawing on the field, the part of computer science often called formal methods. And formal methods is the study of how to use computers to solve logic problems. Okay, and one of the things that when I was a graduate student, people were trying to build these automated reasoners, and what they were trying to do was they were trying to build one tool that could solve all the problems. And one of the things that people discovered in the 1990s, 80s, 90s, and the aughts was that that's a bad idea. You can't have one tool that solves everything. What you want to do is you want to pick various problems and solve one of those problems. Then you move on to the next one, you solve that problem, move on to the next one, solve that problem, and then stitch them together. And the great achievement of formal methods of automated reasoning we live with every day. The reason why your computer does not crash all the time is because the programs are put through theorem provers to check if there are any bugs in them. So the approach of not trying to solve everything with one tool, but try to solve individual problems and see if you can add them up. I want to draw on that. What I want to say is we shouldn't expect there to be a ChatGPT for law. That is one LLM or one AI model that was going to solve all problems. But generally, that does not work. What is the key to automating legal reasoning? What I want to argue is that what you want to do is you want to pair the legal problem that you're dealing with the technique that you wanted to solve. And what I want to argue is that there's not one kind of legal reasoning. There are many kinds of legal reasoning, but in general, what I want to do is divide things crudely into 2 parts. One, I want to talk about rule-based legal reasoning, and then case-based legal reasoning. Now, I'll tell you what I mean by that in a second, but what I want the argument that I'll be making in this lecture is that when it comes to rules, we should be using things like automated reasoners, logic solving tools. Whereas when we deal with cases, we should be using large language models, the kind of generative AI that is used in Claude and ChatGPT and Gemini and all those things. So what I want to do is I want to say there's a difference between rule-based decision making or rule-based legal reasoning and case-based legal reasoning, and that when you're dealing with rule-based legal reasoning, you're using different techniques than you can case-based legal reasoning. What do I mean by rule-based legal reasoning? Well, I mean rule in the kind of the common sense way, things that are like really detailed, really hard to follow, just super technical, and just pains in the neck. And so here's an example. This is tax tables for individuals. This one is greenhouse gas emission for light duty trucks and medium duty trucks. I love this. This is The rules about mustard. You know how many rules we have about mustard in this country? So many. There's coarse Dijon mustard, which is different than Dijon mustard. Now you think, oh, okay, that's funny, right? So he put like a little thing here that shows that there are these regulations about mustard, but really there are regulations about mustard. There's so many of them. The titratable acid, the salts, the solids. That's what I mean by rules. Okay. You know, if you pivot from rules and you go to cases are like the things that you see in the United States reports. United States reports obviously has these Supreme Court cases in it, and in a case you're going to have a plaintiff and defendant or an appellant and respondent. This one is a super interesting one. I picked this just at random, but it actually is habeas corpus. It was an action for habeas corpus relief on behalf of Happy, an elephant residing at the Bronx for false imprisonment, and they claimed that they had standing. And excuse me when I say this, but Happy not happy because they lost this case. And so one of the features about case-based legal reasoning is just there's so many cases, like all over the place, and you have to figure out what the pattern is through those cases. That's kind of what you learn in law school. Like there are all these cases. What's the rule? What's the law? So what I want to do, and I can do a little demo here too. So really don't be that. We have two kinds of bots, AI bots. Okay, for rule-based legal reasoning, I want to say what we should do is create, and I'll show you what some of these look like, code bots. And code bots would be used for environmental regulations, tax provisions, government benefit regulations, whether people are entitled to food stamps, whether they're entitled to government provided housing. And there, what you're doing is you're trying to answer questions that appeal to really, really, really complex and convoluted code bases. Whereas the case bots are very different. The code bots want to give you the answer under the regs. The case bot, what it wants to do is it wants to consume the cases in the area that you're dealing with, and it wants to provide memos, drafts, things that are what we would largely call work product. Okay, I don't think you want an AI bot to tell you what the law is, because it's not even clear in case-based reasoning what is the law in that case. What you want, I think, is some kind of reasoned discussion of how the past cases and work products can generate further and better work products. Let me try to get more into detail here. So let me talk about the code bots. Remember, there's code bots for rule-based decision-making, case bots for case-based decision-making. Let's talk about how would a code bot work. Okay, this is how ours work, the ones that we build at our lab in New Haven. So we take laws, regulations, policies in English, and then what we do is we create what's called a specification. We convert it into first order logic. We convert it into math. Okay, using customized LLMs, which I'll show you in a minute. Once we got the law translated into logic, what we do then is we build these impossibly large decision trees. They're so big. These trees are so big that, of course, what they do is they work out all the possibilities in the regs. They're so big that early on, we ran out of atoms in the universe. Like once you get more than 45 predicates, you really just run out of atoms anywhere in the universe to be able to represent this. So we had to it was so complex, we had to do it in stages. So there's a lot of engineering that went on behind this. And then finally, create from this a GUI front end. What's a GUI front end? Graphical user interface. And so I'm going to show you an example of this. So the first code bot we made was for faculty handbook, Yale faculty handbook. And I'll explain to why we did that in a second. But so this is the thing about the faculty handbooks. I know from like reading a lot of these now, really well done. They're really precisely written, but they're very hard to read. And so what we did is we took this and we converted it into logic. You know, this is what's called prefix notation. The logical operators are put in front, not normally in the middle, to deal with ambiguity. But we translate the English into logic, and then we create these decision trees. Okay, and this one has to do with fellows, who's a fellow, what kind of fellow they are at Yale University. And then finally, so one of the things that you have when you deal with AI, as we all know, is this experience of asking a question to a chatbot, giving a beautiful answer, and then a couple of days later, or even like an hour later, asking the same exact question and getting a different answer. Now, why does that happen? That happens because LLMs, large language models, are what you might call guessing machines. They're incredibly good guessers. They will guess things that you haven't told them was the case, but is most likely the case. So sometimes what it guesses is correct, and sometimes what it guesses is not correct, and sometimes it guesses things that are ambiguous and just flips its answer. I mean, the whole idea of generative AI is to be generative, is to create new things. The problem is that those new things may not be true, and they might be inconsistent with the things that came beforehand. The reason, and then, well, of course, we're actually on the lead. So the way that we deal with the problem of hallucinations is something called neurosymbolic AI. Neurosymbolic AI means what we do is we take the natural language and we translate it into logic, and we let these special things, which I described before, called automated reasoners, they are like calculators. They don't guess. So when you say 2 + 2 = something to your LLM, it doesn't calculate 4. It guesses that 2 + 2 = fill in the pattern would be 4. Automated reasoners are like calculators. They don't guess. They reason. So what happens is if you take user interface, user responses and translate them into logic, and you take the rules and regulations and you turn them into logic, and then you send them both to automated reasoners, they will send back this technical stuff. But if you translate that back into English, you won't get any hallucinations. Why? Because you're not running these logic things through a guessing machine. You're running it through a calculator. The trick, of course, is to get the natural language, the English, into logic. And that's what I was trying to get run for you. If you can do that, then you can do miraculous things. Let me show you some of the, this is, by the way, the class that we taught. It's called Law Security, I think in 2022. And we taught, we had half law students, half computer science students, and we taught them like really like kind of, I think, cool stuff. And this is the Foreign Intelligence Surveillance Act. I just want you to see on the side, this is a translation into logic of this, okay? And once you take this, there's like a simple program, it's called Z3. If you type Z3 into Google, it'll fall up in automated solver. And if you just click that, and you cut that and you just put it into the window and press return, it would tell you whether the thing was consistent. It would tell you a lot of miraculous things. One of them I'll get to is exactly this. Compliance is you want to know, is this electronic surveillance under Foreign Intelligence Surveillance Act? But there's something else you can do, and this is really powerful. You can do exploitation. What is exploitation? Exploitation is, how do I ensure that this isn't electronic surveillance? Put it this way. Let's say you have a set of rules and regulations, and you want to know whether you're allowed to do something. You can't ask it using what I just showed. Or you say, I really want to do it. Show me how I can do it. That's exploitation. And the thing is, when you put something in logic and you say, is this possible? It will find it if it's logically possible. This means that I have been able to break statutes and contracts at will. What do I mean break them? Like the contract will say, you have to pay $50 if you get the widgets. And I'll translate it into logic and I'll ask it, is there a way not to have to pay $50 for the widgets? And it will show you, this is what I took the, please don't tell anyone this. I took the Computer Fraud and Abuse Act, which is the main statute for hacking. And I said, I converted it into logic, and then I asked it, is there a crime that you can commit that gets you a certain amount of years? But you commit the same crime and another crime on top of it, and you get less. So more crime, less time. And the damn thing spit it out. I did not realize that it was like different buckets. There's like Schedule G and Schedule K, and I didn't realize that the various things were interconnected, and it showed that they commit one crime, but if you commit another crime on top of it, you can get less time in jail. Great lawyers are those who can see these patterns. Now we don't need that. Now, if we translate these things into mathematical formalism, we can use these solvers just to tell us how to either that we have to comply or that we can break it. Okay. There are a lot of complications, and I won't go into there. Maybe I'll just skip. I'll skip this. The problem of non-monotonicity. So one of the things about logic is that the classical logic is monotonic. What that means is that if you can derive something from a set of premises, then you can always derive that conclusion, even if you add more stuff onto those premises. But law is famously non-monotonic. What do I mean? It has exceptions. You can think you satisfy the regs, but you don't. So you have to figure out a way. How do you take something that's non-monotonic and convert it into something that's monotonic? Inconsistency. The laws are really inconsistent. How do you deal with the fact that, how do you translate something that's inconsistent? One of the things that I found out was that, you know how like when you read the US code, it seems all convoluted and like tricky, and it's because it's really long. Like I have not found any inconsistencies in the code yet. I find them all over the place in contracts, but I don't find them in the US code. Bush versus Gore, and people remember that. It's probably for many students who weren't born at the time. But Bush versus Gore, the Supreme Court case, that involved inconsistent statutes. So that happens all the time. Let me skip it. And of course, there's open texture. Law has ambiguity. Law has vagueness. We'll talk, I'm sure somebody will bring this up. I'm happy to talk about that. How do you deal with translating something that's a natural language that has ambiguity and vagueness through open texture? And how do you then translate it into a formal language that does not allow for ambiguity or vagueness? Okay, let me. I'm going to skip all these questions of statutory interpretation. I feel like there's this new field emerging, and I like to call it computational jurisprudence. And computational jurisprudence is when you use computers to engage in legal reasoning. And the question is, what types of ethical and moral problems are brought about because of computational jurisprudence, because a computer found something that a human could not find? What does the rule of law tell us? If it's there, it's just that no human being can find this. A computer needed to find it. You have the same problem in mathematics. Mathematics, there are all these standards that are proven. People can't actually check them because they're too. What does the rule of law tell us about situations like that when we start to encounter this in law? Thank you. Let me talk about, that was code bots. We're going to talk about case bots. So a case bot, up till now, I've been talking about rule-based decision making. And in rule-based decision making, you can translate things into logic and then derive whatever you want to derive. But cases are not like that. You know, Neuer versus Neff. But I mean, you're not going to formalize that. And so how are you supposed to reason about cases if you're going to try to automate it? So the reason why this came about was that I started teaching a media law clinic at Yale 8 years ago, and we represent independent documentary filmmakers. We provide advice about defamation, about privacy, trespass, lots of those sorts of issues. And then I noticed that we had all this work product on our shared drive that we never use, because like somebody would come and we get a new film, we find, we say, didn't we talk about this before? And somebody say, well, go look on the shared drive. Couldn't find anything on the shared drive. Or if we found it, it was scattered among a lot of different memos. This is a kind of standard problem that you have in knowledge management in law firms, is that your work product's all over the place. So I thought, what if we took our work product and trained an AI model? That way we could synthesize and recycle this information in a way that would make it accessible. And so the way we did it was we took a base model. We took like just a plain old LLM, okay? And it had to be an open source LLM because we were working with client data. So we couldn't send our data over to OpenAI because it's confidential. So we had to find these LLMs. And when we started doing it, there were not that many of them. And we would download them and we would train them. And this is how we trained them. What we did was we just didn't take our work product and throw it at the LLM. Because the thought was, how's the LLM truly going to absorb this information? So the first thing we did is we taught it media law. We got the students to teach the LLM media law. I'll show you how we'll do it in a second. But after we created what we call the secondary model, we created a third model, which was trained on our work product. And what we were trying to do is we were trying to mimic the way in which we teach human beings. So how do we teach human beings? So you go to elementary school, high school, college. That's your basic information about the world. And that is what the base model is. Then when you go to law school, you learn legal principles. That's a kind of weird thing about law school. It's like we teach you the law of no jurisdiction, right? I mean, no law that I've ever taught is valid because I'm not trying to teach, the law of New York, the law of Connecticut, the law of Mississippi. I'm trying to teach them about the defense of self-defense. These are the kind of legal principles that we teach in law school. When you go to your job, that's the tertiary model. That's where you learn specific things about the state in which, or jurisdiction in which you're working in. So we did the same thing for the LLM. What did we do? We I had the students teach the LLM media law. How do I do, what is it, how do you teach an LLM, how do you teach an AI model anything? Well, it's actually not that hard. All we did was, you know how like when you type into ChatGPT a prompt, you say, well, how funny is Scott Shapiro or something like that, and you'll type into your prompt, and then you get a response. Okay, so when you train a large language model, you're just writing the prompts and the responses. So that's what we did. So I would come up with questions and I would have them answer them. So I would come up with the prompts and they would answer them. So what are the, what is a privacy tort? What is the invasion of privacy? That's at the very top. The invasion of privacy can refer to any of the 4 privacy torts. States differ on which privacy torts they recognize. It's important to be clear about which privacy tort one means. So what's the next question? What are the 4 privacy torts? What are the 4 privacy torts? There are 4 privacy torts, blah, blah, blah. One of the things I learned very early on was that you cannot just teach an LLM the rules. They will not learn anything, just teach them the rules. You have to give them hypotheticals, which was wild, right? Because that's what we do as like we're not just saying, oh, self-defense has these elements to it, but we go through cases, go through hypotheticals to teach you how to think through it. Same thing with the large language model. The large language model, unless you show the large language model how the rule applies in practice, then it just does a terrible job. So this is the training material to make the secondary model. And this is what we did with this is what we trained the secondary model on to get the tertiary model, and that is our work product. What the students had written over the course of the 7-8 years. Okay, and I carefully redacted. There's no client information there. But there would be client information there. Okay. And so what we created was a tool which we call senior partner. The idea of senior partner was, the senior partner knows a lot, but you really shouldn't trust them. And so, so that was the idea. The idea was that we wanted to make sure that anything that the model outputted, you could check. Okay, and so let me because this see, so it's so unfair. I feel like I know you guys already. It's so unfair because I did this a year and a half ago, and it was so good. It was such a good answer. I asked this incredibly hard question about a photographer who takes pictures, a family. Okay, so here's the hypothetical. The hypothetical is this guy David is taking a picture from his New York apartment across the street to another New York apartment. Family, the Smiths, they have 2 children. The children are unidentified, but they're partially identifiable. But he takes these pictures and he puts them into an art exhibition. And the question is that invasion of privacy under New York law? It's a hard. Now, the thing is, this gave such an incredibly good answer. And what I want to show you is that this is just the raw output. When we trained it to think about First Amendment and media law, the responses, the output that we got was just incredibly powerful. Such that my colleague Robert Post, who's the ALI reporter for privacy, would not believe that a computer did this because he was just like, it's just too good. So I can't do it. I have a demo of this too, but I can't run it now. Also computers. Let me explain to you how the tool works. The tool works in the following way. If you type in a prompt, it gives you the response. But as it's giving you the response, anytime it mentions a case or facts in a case, it automatically checks to see whether that's a real case and whether those are the facts. If they are, it gets green underlined. If it is a little off, it gets yellow underlined. And if it's red, it's a complete hallucination. So if you click on the red, it will not, it'll say this is a hallucination, but it'll say, here are the 3 cases that are closest to it. So we're going to expression, never let a hallucination go to waste. The fact that there's a hallucination means that a model thinks there should be a case here. So it will go look for one, a real one. It takes all the training data and puts it on the side so you can see where the model got the information from. And what it does is it constantly allows you to, every time you change something, it will check. So the point of senior partner is that anytime you're dealing with an LLM or a legal AI tool, it should be a requirement that you can check every aspect of it. So when we build tools, when we build the code box, it will tell us exactly the chain of reasoning, how it got there. For the case spots, what it'll do is it'll check everything to make sure that everything really, in fact, exists and shows you where in the training material it got it from. So you don't have to say, yes, this is right. You could just rely on it. So let me, oh my goodness. Let me wrap up with the following thing. So I described that there were these 2 kinds. There was rule-based decision-making and case-based decision-making. I said that they both had to use very different kinds of techniques. One LLMs, the other one was automated solvers, translating one into logic. The other one, you have to, everything is text-based. Could you just one day, do you imagine that we would be able to eliminate one of the categories? Maybe what we could do is we could translate all of the cases into logic. Why can't we do that? Why can't we truly realize Leibniz's dream by taking all cases, translating them into logic, and somehow figuring out what the right answer is? And I want to argue right now that's not possible. And that to think that is to misunderstand how law at its foundation works. Okay, let's talk about environmental law versus constitutional law. Environmental law, it's got very dense rules, has very precise concepts like light body truck or methane or whatever. High logical complexity, but low moral complexity. Okay, it's just really hard to figure through, but it's not that it's taxing your casuistry or your moral reasoning. Is just really, really tricky. Constitutional law is like the opposite. It has very sparse rules. It has vague concepts. It has high moral complexity, but low logical complexity. So it's really, in a way, like the flip side. In environmental law, when we are regulating CO2 emissions, we have what engineers would call a complete specification. We know what we want. And because we know what we want, we can be very, very precise about how we're going to get it. Constitutional law, we have a very incomplete spec. We have a very incomplete specification. We don't exactly know what we want. Due process, fairness, equal protection. What's that? The problem with constitutional law, as opposed to environmental law, is that in constitutional law, we're not quite sure what we want, but we want to reason about it anyway. Because due process lacks a precise specification, we can't draw up statutes and regulations for it because we wouldn't know what we were trying to implement. Incomplete specifications allow for case-by-case regulation because we may not know what we want, but we may know when we have it or when we don't have it. The common law evolves through iterative decisions forming precedential patterns. Think of the common law as if it were a neural net, an LLM. The common law was designed for things like the constitutional law type pattern, where we don't really know what we want, but we know what it is when we see it. Okay? It is amazing that we can actually get answers to questions when we're not even clear what questions we're asking. That's incredible. When we know exactly what we're asking, we can draw up algorithms. Like, for example, stupid. No, it's not even on that. I don't know why. Please excuse my my visual code update screen. So basically, when we know what we want, human reason is split into two parts. Things where we know what we want and things that we don't know what we want. In theoretical reason, what are things we know what we want? Like, let's say if we wanted to sort numbers, then we could write a little sort algorithm or whatever kind of algorithm we want, okay? What happens when we don't know what we want? Like, what does a cat look like? We know what a cat is, but we don't know what a cat looks like. That is why we have to use neural nets by giving thousands, millions of pictures of cats and not cats to train it. Okay? Why do we do that? We do that because we don't know what a cat looks like in the abstract. We can't specify what a cat looks like in the abstract, but we can give it millions of pictures of cats. Just like that, there's a division in human reason between things we know what we want, things we don't know what we want. In theoretical reason, the same thing is true in practical reason. Sometimes we know exactly what we want, like when it comes to environmental law, and sometimes we don't know what we want, like when it comes to constitutional law. The reason why we will never, ever formalize all of law is because we will never, ever truly get a complete specification for what due process is, what freedom is, what equal protection is. There's always going to be these questions that we have a vague sense what we're asking, and we know how to identify examples, but we don't know how to specify in the abstract. Because we don't know how to specify something in the abstract, there's no chance that we're ever going to come up with a logical specification which implements it. What is incredible and what I want to leave you with is that neural nets and the common law are alike in the following way. They are amazing devices for getting answers to questions that we're not sure what we're asking. When people say, oh, AI, how do you align AI with human values? I often think we don't know what human values are. In some sense, that's what we do in a law school. That's what we do in a philosophy and religion department. We try to get better about what the specification is. What is due process? What is freedom? But we're not under any illusion that we're ever going to get to the point where we can truly specify technically exactly what we mean. And can't do that, we'll never be able to logically translate the law into mathematics. And we'll have to deal with the fact that we have two kinds of issuance, code bots and case bots, instead of one tool to rule the law. Thank you very much.
All right, we will now open the floor for Q&A. Who's got a hard-hitting question for Dr. Shapiro? Oh, good. You can call away back here. Oh.
Okay. Hi, my name is Nathan Williams. I'm a 1L here, back here.
Oh, great.
Would you argue or say that there's some argument for, because we know what different parts of the brain associate to different types of thinking, that maybe we study first instances of constitutional law, like the complete precedent of what necessary and proper means or due process, and then maybe go in a future study of how judges are interpreting that same language, but with a connection to what parts of the brain are working as it's being interpreted, so that maybe you still have a logic piece, but you can't necessarily translate it into the code without the work after doing that later logic.
So, maybe I'm not fully understanding. So we don't know what happens in the brain, but let's say we did know what's happening in the brain. It's highly unlikely that what's happening in the brain is it's doing logic solving. The reason is because, and so the point I was trying to make is that if you have incomplete specifications, if you don't really know what you want, then you can't really use logic in the way that I was describing it, because you don't even know what you're trying to answer. What is amazing about the brain is that it does not know a lot of the things that it is tasked to figure out, and can put piece by piece together, and then somehow magically we're the reasoning part of the brain is able to increase the levels of abstraction and figure out general rules about things. I don't think we're anywhere near that when it comes to constitutional law, and I'm not sure we ever will. So,
hello, my name's sorry.
Sorry.
My name's Jason Cunningham. I'm from Nashville, Pennsylvania, and I'm an undergrad in illness. I'm seeing a bit of a disconnect between the underlying moral background that we lay for this kind of automated legal reasoning and how it works out in practice. So at the beginning of this lecture, we talked about how there are good implications that this can have to help the 74% of low-income families that have legal issues in any given year. However, when you started to talk about the way that this program would need to be developed, we have the base, which is the general knowledge. Okay, we can give that to the computer system for the families to use. The same for the secondary, which is the legal principles. But then when we get to the tertiary, then we need to have this system have memos and client data and other proprietary confidential information, up until the point that you can't even show us how this works on the screen here.
Yeah.
So how is implementing this not simply going to continue to drive the wedge further between the low-income families and the white shoe law firms who hold all the data?
Fantastic question. Thank you. And I was, so let me talk, it's how, so one of the things that we try to do at the lab is try to show how we can deploy this technology to bridge access to justice problems. So the first thing I would say is that code bots, you could give code bots to users, okay? Because you could put it on the web. What I think the most interesting model is, and what we're working on right now, we're working with the Legal Services Organization, we want to give these code bots to lawyers so that when people, local families have problems, they call up the Legal Services Organization, and the Legal Services Organization would have lawyers who are working for them pro bono who don't know the area of law, but since they have the code bot, they can answer these questions. So the code bot is supposed to engage in AI assistance of either users or lawyers who are helping them. I would never give a case bot to a user. Case bots are just for, because as you so correctly pointed out, the case bot is supposed to produce things like memos and briefs. So you don't want to give that to people who are not, trained in law.
So that would be, we use that for our films. So we do the films pro bono. We represent these filmmakers pro bono. And so when a new question comes in, we'll use the tool to get better information. But we never share that with the client. So whether something is who's going to use it and when is one of the things that I'm very, very much focused on right now, because you could build a tool and if it sits on your hard drive and you put it on a website and nobody sees it, it's not going to do anybody any good. So what we've been doing is partnering with various legal services organizations to figure out how they can deploy these tools. So you're absolutely right, and I should have been clear about that. Thank you.
Hi, thank you for the lecture, it was very informative. I just had a question about, could this also be used to help inform like legislators in creating the law?
Yeah.
I know so there's not too many inconsistencies in it, but to make the law more consistent, especially like the state and local levels.
Yeah, so thank you. So I'm doing this project right now for Connecticut. Connecticut had their election laws change all the time. And they have lots of inconsistencies in the law, because it's changing all the time. Like the second Tuesday in October, November, that changes and it may, being consistent with other things. So we're right now looking to help Connecticut figure out where the inconsistencies in the laws are. One of the things that people said was, oh, this is great. You can give your tool to legislators and they can see whether they're inconsistent. And I know exactly what would happen, is that it would find its way into a lobbyist shop, and they would figure out how to insert Easter eggs into the legislation. To benefit their clients. So ideally, it would be great. I'm not going to pitch legislators on this because I just know the way it would be used.
Thank you.
I think it was last year, our University Center for Practical Ethics actually had a student competition to discuss whether or not AI could be used to formalize judicial decision. And then we could use AI instead of judges. I think may have been inspired by some of the reports coming out of China about their limited attempts at doing this. And my limited knowledge of Chinese law is this very code-based. And so I'm wondering if your code bots, for certain purposes, just what your thoughts are about whether or not doing that with judging cases.
Yeah, so I'd say that. So first of all, thank you. Those are two excellent questions. The first one is, what do we think about judges using AI in the courtroom? So let me give you my take on this, which is like, what's the point of a courtroom? It's not just to decide whether somebody is like liable or not. It's a form of accountability. It's where you go and you make your argument, and the other side, they make their argument. Judge has to figure out, okay, who should be held accountable for whatever mess happened. The problem is with large language models is that they are so to speak, unexplainable. What does it mean, unexplainable? It means you don't know why you got the result you got. Okay? Again, it's not surprising that generative AI is unexplainable. After all, we don't even know what we're asking it. That's what I want to just kind of keep on harping on, is that like we're asking generative AI questions because we're not particularly clear what question we're asking. If it was particularly clear what question we're asking, we could use a calculator. Okay? We're asking the LLM because we're not quite sure what we're asking. And the way that the LLM to really complex matrix manipulations and linear and nonlinear transformations, tries to generate a best prediction of the next word that you, based on the prompt. So this is what happens in LLM. You take the prompt, you send it in. What the LLM does is it calculates the probability that the next word will be something after the prompt. So 2 + 2 equals, LLM will assign a very high probability to 4. Okay. Now, how does it do it? If I showed you the inside of a large language model, it would just be billions and billions of decimal floating points. What you would see was 0.00134556. The next one would be 0.6133. The next one would be negative. You're like, what is this? Like, what is it? Like, what's going on here? And this is a big problem, is that nobody knows what that means. Why is that a problem for us? It's a problem for us is because if a judge is using the LLM to make a decision, even if that is on average a better decision, the court and the judge are not playing their role of accountability. The point of a court is to say, you did these wrong things, you did these right things, therefore you're responsible for this. But if you take all that and you put it into a machine that it may give you the right answer, but you have no idea why, then the court and the legal process is not doing the most important thing it's supposed to do, which is not hold people liable, but explain to them why they're being held liable. So I'm not a fan of having judges do this because I really want the judge to explain what that judge's judgment was. Now, one other thing you said about China, the Chinese legal, Chinese law is about structures. I don't know anything about Chinese law, but I know enough about American law and enough about civil law to know that, like, we should not always pay attention to the surface form. Okay, so like take sec regs, securities regulation. You might think, oh, securities regulation, that's a regulatory thing. There's got all this code, but of course it's not regulatory. I mean, it's regulatory in one way, but it's like you have to worry about what the SEC thinks. You have to worry about what the Second Circuit thinks. You have to worry about, what the Supreme Court thinks. Take even like individual income tax. Individual income tax is not determined purely by the code. It's determined by IRS decisions, IRS opinions, guidance, and things like business purpose and equity, which does not formalize well. So one of the things that I think it takes some legal judgment to know, does something fall into the rule-based camp or the case-based camp? Because some things that you might think fall into the rule-based camp are really not rule-based. And the same thing I would say about the Chinese case. I don't know. The fact that it's in a code doesn't mean it's amenable to a code file. So that's the problem.
Hi, I'm Jeff Jordan. I'm a senior here and I health law for last year. My question really fits with these previous two. And it's really because my eyebrows went up when you said all these things about incomplete specification. I feel like that imports some really hefty assumptions about legal reasoning and legal interpretation. And personally, I'd be more inclined to say that, yes, there's art and science to it when you're defining due process of freedom. I mean, due process and when bodies you for freedom. It's a lot. Fine, I understand what you're saying. But that's for the legislative. Maybe the legislative needs case bots. But the interpretive function of the law, lawyering, and the judiciary, maybe code bots are exactly what we need, no more, no less. What do you think of the claim then that, if you're doing something that a code bot can't do, if you need a case bot to make your case, you might be doing activism, not interpretation?
Yeah, so that's a great question. So you're pushing me exactly on what the kind of the thesis of the lecture is. So so thank you for that, let me just say the following. You could take due process, you could take freedom, you could take equality, and you could try them all. And you could try to translate it into logic, and you could try to use code blocks on them. But would you really be doing something that's legally reasonable? So what you would be doing is you'd be taking something that you know you don't have a precise grasp over, and then putting it in the form as though it had that precision. And that, I worry, just distorts the law. One of the things we have to recognize, I believe, I mean, this is why, again, everyone's entitled to argue with me about this, because like, people are entitled to argue with everyone about anything, but one of the things that I firmly believe that the question about legal AI is really a philosophical question. It's about the nature of law. If you want to know what kind of tools to build, or if you build a tool and you want to know if it does a good job, you have to have a certain theory about what law really is and how legal reasoning works. And so one thought might be, we don't ever want the law to be deep trafficking in concepts that we don't have a clear enough specification. But if we do that, then we end up not talking about so many things that we care about in life. Like, what would a reasonable person do under the circumstances? Is this equal protection? Did you violate somebody's right to free speech? We can pretend, and civil law countries do this, they can pretend that they can take those concepts and formalize them and put them in a really, really elegant and complex code. But that would, I think, be distorting what we're really doing. Because I think what we're really doing is we're faking it in those cases. We're faking it. We're acting like we know more than we do. And the fact that a legal system does it doesn't mean that it's the right thing to do. One of the things we know from jurisprudence is like lots of times judges say things which are ridiculous. And our dad is like push back. But to your question, I just think that were we to try to codify everything because we just want judges to follow the code, that would be distorting what we're really doing, and we would be giving hostages to fortune. So H.L.A. Hart famously said in the concept of law, he said, formalism, by which he meant a situation, a theory where you always know the right answer to any legal question. He said, formalism is impossible because you can't come up with a precise specification for everything. But he said, it's not just that formalism is impossible, it's undesirable. It's undesirable because we would be acting like we have the right specification now, and we haven't thought about 99% of the questions that come up. So we can pretend that we've thought about things, but that's not only is that not possible to do in reality, but I don't think you should act like you can do it in fact.
Thank you. I found the distinction you made between compliance and expectations with LLMs interesting. And I can definitely think of instances, like you said, where there would be good cases, say, for privacy or consumer protection. That being said, do you have concerns of this technology falling into the wrong hands? Say, so like further exploit legal loopholes, like tax benefits and things like that. Moreover, on that note, how do you ensure that you'll have the real egalitarian benefits for low-income households? I know you said that obviously you would want lawyers to have these tools, but I don't know how that would necessarily break the barrier to entry for low-income households if they're only accessible to legal professionals. Of course, you did mention that you would want this to be accessible online, which I think would definitely help that, but yeah.
Yeah, so, thank you, yes, two questions, the question, the first one was, just remind me the.
Yeah, the first one just being, do you fear this type of?
Oh, yeah, one hand.
Yeah.
So let me just say the following things, let me talk about exploitation. So I wrote this, it's a previous, the last book I wrote is called Fancy Bear Goes Fishing, and it's about, cybersecurity. And one of the lessons that I learned from my foray into cybersecurity is that all security tools, all tools in general are dual use. There's no such thing as a tool that only does good things. Okay, so we love encryption. We love encryption because it enables privacy, except when it's called ransomware, right? We love locks, except for imprisonment. I mean, so like the thing about law, anything has its dual use. I was sitting. Okay, so let me just say what happened. I was teaching this class. It was in 2022. I told you it was called Law, Security, and Logic. And Rushka, my co-teacher, she showed this example by David Besson, who's a formal methods researcher, and she showed that it's possible to break the European cryptographic protocol for credit cards. So you go and you swipe at the point of service, and then whatever, and then you take your stick of gum, right? So it turns out that this is how it works. There's something called a nonce. A nonce is just a random number. Okay. So the cryptographic protocol works as follows. If you swipe your card, the point of service sends a nonce to the bank or whatever that network provider is, okay? And they send back another nonce. That's the handshake, and then they start. Besson takes the cryptographic protocol, he converts it into logic, he puts it into Z3, and says, is it possible to break it? It turns Z3 automatically says yes, and he looks, and how does it do it? So when you swipe your card, you send one nonce over. All you needed to do from the other side is send exactly the same nonce back, and the whole thing breaks. And I was sitting there, and I was like thinking, if you can break a cryptographic protocol, you can break a statute, you can break contracts. There's $16 trillion in private debt out there for contracts that nobody's ever read except for the terms. It's going to be shooting fish in a barrel. How to exploit those contracts, how to exploit regulations. Now you say, how do you make sure this does not fall into the wrong hands? You do not. There is no way to do that. I don't. And so people say, well, should you be teaching this? Well, it's not going to take that long for somebody else to figure it out. I think that if you ask me prediction, do you think that this will be used in legal practice? I will say yes, 100%. But why wouldn't you? I mean, why wouldn't you use a logic program to break whatever you want to break? Of course you're going to do it. The question is, can we use this knowledge in an arms race to do more good things than people do bad things? Okay, how would it, again, with the case bots and the code bots, this is not a technical question, it's a socio-technical question. How do you get this thing? Let's say the thing works perfectly. How do you get it into the people's hands who need it? So what I was thinking about when I talked about the pro bono attorneys, I was thinking that, take eviction. So this is obviously a very big problem. Eviction is a crisis in the United States. And so let's say some family is worried about being evicted and they call up the legal services organization and say, can you help me? The idea, this would be the hypothesis, the idea, and which we're trying to implement now, is you would give these programs that would take the landlord-tenant law and the statutes, the relevant statutes about eviction, and then you would build a tool for the lawyer. One of the things I wanted to mention, and of course I couldn't because of the problems with sharing the screen, is that the tool is a continuous tool. If you just give it rules on one side, it automatically generates a program that answers your questions about the rules on the other. So it just kind of goes through the pipeline and does everything. And so the idea would be for us to go to legal services organization, say, what kinds of laws do you deal with for, let's say, eviction? What are your biggest problems? Is this amenable to a kind of rule-based legal reasoning? And then build them a tool so when people call up, the lawyer themselves doesn't have to know what the landlord-tenant law is. They could be a corporate lawyer. They could be draft wills for a living. But at night, they could use this tool to assist people who don't have access to legal care using an AI program. And that's that. So it's not like I feel like I want to build a tool that's not going to be used for bad. I know it's going to be used for bad. I want it just to be used for good and get a head start.
Okay, we're down to our last 5 or 10 minutes here. I got one more question back here and then up here. So.
Hi, my name's Madison. I'm a third-year law student. Can you explain how we're helping low-income individuals with this kind of program when these are the same communities that are being polluted by AI data centers?
Oh yeah, that's an excellent question, and I that's above my pay grade in the sense that I don't have control over this. But your point, environmental injustice is a serious problem, and it's an ignored problem. The activism about data centers in the last 3 to 6 months has been very encouraging about controlling the really out of control hyperscaling that is going on. And so I wish I could, and I want to just affirm that like the concerns that you raise are really valid. Article was in the Times of the Bosch. I've got very regular about in Texas in order to create generation of electricity. They've been using these jet turbo engines, and it's causing so much noise that people can't live because it's just so loud. So there's not just the environmental pollution like in terms of air and rising costs of electricity, but there are also noise pollutions that actually are a big problem too. But so thank you for the question.
Okay, my name is Professor Pitt, and I teach you. My question to you is: do you do anything to prevent implicit bias from seeping into their systems?
Yeah.
Do you see that as a problem?
Yeah, thank you. So one of the things, at the lab, we care a tremendous amount, okay, is to not only be intellectually responsible, but morally responsible in our use of these tools. And one of the things that we do, and one of the basic principles, is that you always want to make sure that the AI model shows its work. So you can check if there's something funny going on. So for the code box, it's hard to see how implicit bias works its way in because you're just translating the thing into math and just using calculators. The only way in which you could see implicit bias working would be with the case bots. So the case bots use cases which are just filled with bias. It's like cases are like, if you want to understand you know, we're a society, biases of a society, read a case. But what happens with our case spot senior partner is it always tells you where it gets its information from. Okay, it will always show you the case that you're talking about. It will always show you the training data it's using. So it's hard to see where the implicit bias would creep in, if it creeped in, but if it did, the idea would be for the tool to show all of its work. So if there is implicit bias, it would then be made explicit. And so it's really important to me that these, despite the fact that I know that these tools will not always be used for good and will often be abused, my job as a professor is to try to build ethically and intellectually serious tools that enable users to be able to check the work so they don't have to trust a black box. And my message going forward is not just that we want to make sure that we use the right techniques for the right kinds of legal problems, but we also want to make sure that whatever tools we do create always make clear the basis of their decisions so we can make the decision about whether we want to know or not. Thank you.
All right, that's about 5:30, so let's thank